You know?
Here we're in public session.
Thank you. Good morning, everybody. Welcome to the May meeting of the New York State Joint Commission on Public Ethics. Item number 2 on the public agenda is approval of the minutes from the April meeting behind attachment A. Can I have a motion, please?
So moved.
So moved. Thank you. Seconded is George.
That's Commissioner Yates and then Commissioner Weissman.
All in favor?
New York City, 3.
Albany.
Gary, are you in favor? Yes. There we go.
He's got the
And
whole
all
screen.
Albany?
He's-
Okay, unanimous.
Okay, it's unanimous. Item 3, report from staff.
Yes, Mr. Chairman, I'll pick that up. Outreach update. About 3 weeks ago or so, I did a CLE presentation for the State Bar on financial disclosure statements and the law around that. As you can imagine, a topic like that was scintillating, but it was, I think, well received. Actually, a week later, I was asked. I appeared in in terms of outreach, a panel discussion for the Nassau County Bar Association on restoring confidence in government. As a result of the FDS presentation, they asked if I would join that panel. And it was fascinating. It was out in Mineola, and it was on a panel with the UN Chief Ethics Officer, taking more of an international perspective. Actually, I was talking to her, and I said, I have really 14 commissioners that I answer, to. And she goes, well, I have 193 countries that I answer to. Her aide interrupted and said, no, it's up to 195 as of last week. It's 195, and depending on the issue, we need a majority of the 195, a super majority of 195, or Security Council vote with several countries having vetoes. So I said, we have a very smooth running process here in New York State. It was a very good presentation. This October, we are preparing as a follow-up to what was done last October, a half-day session down in New York City, and we may do a session up in Albany looking at lobbying. Last year we looked at ethics enforcement and some other topics as well, in conjunction with the City Law Institute New York Law School. So we are in the process of setting up something similar on lobbying, with emphasis on lobbying this coming October. So that's what I have for an outreach update.
Thank you. Attachment B, legislative proposals.
Yes, Mr. Chairman, just as background, staff prepared and posted on the website in 2017 just legislative proposals, items that staff had drafted. There are 3 that are listed for 2018. To let you know, the 2017 proposals, there are 3 of them that were picked up by the legislature. Now, the commission didn't put its imprimatur on this, did not vote to endorse the proposals. They were put out there for discussion. Currently, Assemblyman Buchwald in the Assembly has bills A7161, which deals with passing money through a straw man, A7162, which deals with aiding and abetting and accomplice liability, and A7163, which raises the penalty to a felony to knowingly and intentionally file a false statement with the commission. Those 3 bills are live in the Assembly. They're still in the Government Operations Committee. They have not been introduced in the Senate. And as we did last year, we had invited the legislature and the executive to come in and discuss these bills if they had any questions. I don't think those discussions took place, but they were out there for comment, and I had several discussions with Assemblyman Buchwald. In any event, just to give him background. This year we have 3 proposals that are included. We are not asking, and it's up to the commission to vote, so, but we're not asking for a vote. For discussion or any comments the commission has, a reform that is somewhat similar to what exists under the, in New York City, where lobbyists disclose contributions, political contributions, and political consulting activities as well as part of their lobbying. Excuse me, fundraising. Excuse me, that's correct. Not contributions. They're fundraising activities, political fundraising, soliciting contributions. So that actually will, and it's something that we've learned from our experience here, would be of importance. We have reform similar to the one that's 7162 that's already been introduced, involving accomplice liability for individuals that aid in committing violations that are subject to JCO jurisdiction. And we have another reform that I guess it's sort of a penalty raiser, but it tries to put some more meat on the bones and penalties for failing to file or filing a false statement, including periods of debarment from lobbying, and an extended look-back period where we can look for repeat violators. Right now, for some of the repeat violations, it's a 5-year look-back. The proposal is for a 10-year look-back in some situations. And it would also enable the commission in imposing penalties to see if the entity committing the violation is really the similar entity or similar individual as another entity. We've seen situations where people will file, create a corporation, file, or fail to file. There'll be a violation found, and they'll simply create another corporation and act similarly. This will let the commission consider this periods of debarment when looking at these individuals as to whether they've committed acts under the guise of other corporations. If the commission has any comments or thoughts on it, it's obviously late in the legislative session, but we've put them out here for any comments or thoughts the commission might have, and I'll leave it to the commission if the commission wants to formally endorse them or not. We're not in the legislation business, but these are reforms that would certainly strengthen Jacob's ability to fulfill its function.
Commissioner.
Seth, if you don't mind, I had a couple of questions. On the political consulting, how does that overlap or not, or underlap with in-kind contributions that are reported under the election law? In other words, would a consultation that's not an in-kind consultation still have to be reported here if it's consulting by a lobbyist?
It doesn't, Commissioner, it doesn't bear on whether or not an activity constitutes an in-kind contribution under the election law. It's based on the definition that's laid out in this proposal for a lobbyist, and it's based on whether or not they would normally be compensated for such activity. So whether or not it's reportable as a in-kind contribution under the election law has no bearing on this requirement.
Because the political consulting activities do not have to relate to a campaign. Isn't that correct? In other words, the political consulting can be, at least the term that we've defined, it means just providing, well, it's actually an election campaign, but if it's a person who's already been elected, it could be consulting advice to that individual elected official. So it doesn't necessarily even have to be doesn't even have to be related to an election activity.
Right, but if an election campaign is in progress, what you're saying is even though there's no in-kind contribution that has to be reported, the fact that they had a conversation would have to be reported. I don't know.
If that conversation meets the definition, yes.
The answer is yes. All right. And I think that may be one of the reasons why you don't have a lot of movement in the legislature. Going on to the second one, the second proposal, the aiding and giving advice, does that mean that if a public official is consulting and getting advice from, say, a counsel or someone else, an ethics expert, and and it turns out that for one reason or another the activity is illegal, then even though the counsel or the person who gave advice is not a regulated person under the jurisdiction of the commission, then the commission would still be able to go after that person if the advice was given with the intention of aiding the public official.
I think, Jim, I say yes and no to that. The state, as in any accomplice liability statute or the way we deal with it under the penal law, the mental culpability that the accomplice has to be the same as that of the primary of the principal in the action. So it has to be with acting knowingly and intentionally violating the law, or knowingly and willfully failing to file with intent to deceive. If someone is relying on the advice of reasonable advice of counsel, that's first of all, that could be obviously a defense to knowing and willful. If you have an attorney that's actually engaging in a scheme to defraud, and as part of that, I think that the criminal law would even pick that up. If the question is, are we going to pick up people who might not otherwise be subject to our jurisdiction? If they are aiding in that, the answer is the proposal would say yes. If someone is outside and they are helping you engage in the fraud with the idea to defraud the public by filing a false statement with the intent to deceive, yes, that would pick it up. But I think merely getting advice from counsel or advice that's not part of that scheme, that wouldn't be covered.
Yeah. Well, the problem for me there is that intent, as you know, is always an iffy proposition, and it's usually proven by circumstantial evidence. So in effect, if someone, say, in the executive chamber were to turn to a lawyer in the executive chamber and say, can I do this, that could then mean that the lawyer in the executive chamber is now going to be at least having to defend his mental state at the time he gave the advice. And that's problematic for me.
I understand that, but typically if someone is saying I relied on the advice of counsel, that's recognized as a defense under the criminal law anyway. And actually, in this case, we're dealing with, obviously, most likely with civil penalties rather than criminal, although there are criminal penalties involved. But anyway, here you go.
All right. And then my last question, because I don't really want to belabor these things, but on K, when you talk about a public corporation being debarred, two things there. That includes then under the definition not-for-profits?
No, that's
Nope.
general construction law, right?
Yeah.
Correct.
Public corporations are defined term.
As defined in-
Municipal corporation, district corporation, or a public benefit corporation.
As the commissioner said, yes.
So the answer is yes.
No, not-for-profit is
All right.
not covered.
And there would, no?
No, public corporations are a defined term. Public corporations do not include private not-for-profit
Right.
corporations.
Right, so the private not-for-profits would be captured under lobbyist or client.
To begin with, yeah. They're already captured if they're lobbying.
All right. And then you're assessing joint and several liability against shareholders, members, partners, officers of these not-for-profits or even public corporations. I don't know. I mean, we don't have to debate these things. I'm just pointing out
No.
sort of problems that I saw. I had my old
Thank you.
Anyway.
Anybody else wish to be heard on this? Okay. Moving on. Item 4, regulations, behind attachment C.
So these regulations have been before the commission before. Commission approved a rulemaking. We put them out for public comment. We've received no public comment. These regulations relate to financial disclosure statements, and generally, the issue was the process for applying for exemptions. What the commission did was clarify that in some instances, the executive director will make the determination about whether or not an exemption will be granted or not. And then what the commission decided to do was to allow for an appeal in certain circumstances to the full commission if the executive director denies an exemption application. So that's what these regs were about. This is to make some final, we moved forward on an emergency basis, so they are currently in effect. We do have two minor changes that we want to include based on my discussion with Commissioner Weissman, and we don't think these are material, so this has to go back out for public comment. But in 935.2, J5, which is on page 7 of 935, so it's attachment C, it's the first reg, page 7. It's in the middle of the page, paragraph 5. It says the executive director shall provide the commission with information regarding the nature and number of exemption applications received, and we're going to add and disposition thereof. And similarly to 942, which is the next set of regulations behind tab C, on page 9, at the very top, continuation of new paragraph F. So we will add, the executive director shall provide the commission with information regarding the nature and number of exemption applications received and disposition thereof.
Any comments? We need a motion to approve.
Yes, a motion to adopt these regulations.
Okay, can I have a motion, please?
I'll move.
Commissioner Gearing.
You. Second.
Commissioner Deering, Commissioner
Seconded by
Yates.
Commissioner Yates. Thank you both. All in favor?
New York City,
WebEx. And Albany.
okay.
Okay, unanimous. Thank you. Item 5, new and other business. Who's taking which one? Do we have any?
I don't think we have to.
Oh, okay. Hearing no new or other business, and that, I think, brings a conclusion to the public piece. Can I have a motion to enter into executive session, please?
So moved.
Commissioner McAuliffe.
Thank you, seconded Commissioner Jacob.
Jacob.
All in favor?
New York City,
Unanimous, Albany.
WebEx and Albany.
Okay. Adjourned. Okay, in executive session, we discussed a number of litigation matters, commenced an investigation, authorized several investigative steps, discussed several investigative matters, and closed one matter. That brings to a conclusion the May meeting of the Joint Commission on Public Ethics. Can I have a motion to adjourn the public meeting, please? Thank you, Commissioner Yates. Second. Thank you, Commissioner Smalls. All in favor?
New York City.
WebEx and Albany.
All right, we are adjourned. See you all next month. Thank you, everyone.
Thank you.